and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Welcome back to the Unpacking the Case podcast. Today we are looking at a really interesting Upper Tribunal decision involving EE and Clock Tower Investments Limited, and it's one of those cases that sounds niche at first but actually has some very significant implications for telecom leases and the Landlord and Tenant Act 1954. The issue was surprisingly simple. Can a telecoms operator benefit from the protection of the 1954 Act if they're not physically occupying the actual demised premises? In this case, the operator's equipment was effectively being used through rights over adjacent roof space and access rights, rather than traditional occupation of the land itself. The tribunal said yes, the 1954 Act could still apply, which means there is a very different renewal process. Today we're going to unpack why the concept of occupation for business purposes is becoming increasingly blurred. Good morning, Richard.
Good morning, and what a pleasant one, Lizzie.
I know, we're just bemoaning the rain in nearly the end of May, and it's rainy and miserable today, but we're going to cheer ourselves up with a podcast.
Mm-hmm.
So we're here to talk about a case from the Upper Tribunal, judgment on the 30th of April, and the case is called EE and Clock Tower Investments Limited, and it's all about easements. So do you want to kick us off with some background facts and some background law?
It's about communications equipment as well, and it's about the 54 Landlord and Tenant Act. So it brings in lots of areas. Yeah, I mean, I'll sort of steer clear as best I can of the communications equipment side of things, because it's highly specialist and getting more and more difficult every day with another case or two being decided. But basically, EE and H3G to go to lease of this land on June the 11th, 2004, next to a clock tower in Grays and Essex, the tunnel at the entrance of the Tunnels estate. Don't know Grays, never been there. But they took out a lease for their communications equipment, but never actually occupied the premises, this piece of land. But they did have ancillary rights, which they'd exercised to put communications equipment on the clock tower, anywhere on the clock tower, and they had actually done so. And at a later stage, well, the contractual term expired on May the 31st, 2022. And they wanted to claim a renewal under the Electronic Communications Code, and claimed sort of new code rights under the code. The code came into force on December 28th, 2017, and it's been a bit of an issue for some time. There have been a case, a Supreme Court case in 2022, Cornerstone Telecommunications and Compton Beecham, which had basically said if you come within the 54 Landlord and Tenant Act, you can't exercise the code rights. And equipment prior to the Digital Economy Act coming into force on December the 28th, 2017, would come within the 54 Landlord and Tenant Act. So the question was basically, does the 54 Act apply in this particular situation? Because for the 54 Act to apply, you have to occupy the premises, at least partly for business purposes under a lease. And they obviously weren't occupying the demised land, but can they occupy under the ancillary rights, basically easements over the clock tower? That's what it was all about, Lizzie. It's a complex one.
So what happened in the Upper Tribunal?
Well, they more or less confirmed the first tier tribunal decision. There's a series of cases basically going back some time about whether you can occupy or not, and by virtue of an easement. There was a case called Land Reclamation, the Court of Appeal case, Land Reclamation and Basildon District Council. It seems that Essex is big on these things. But Basildon District Council had basically said you couldn't occupy a right-of-way, an easement for a right-of-way. And incorporeal hereditament wouldn't be premises that were occupied. But then there was another Court of Appeal case called Poynton, York and Poulton in 2007, where they said that that wasn't a blanket rule. Certain types of easement could be occupied, and that was involving car parking. They basically had sublet for 3 days less than the head lease premises, but retained car parking easements. Don't get me onto car parking. It's a topic in its own right. Is whether you can have an easement to park your car, but they basically said it was an easement in these circumstances, and that was sufficient occupation of premises to allow the 54 Landlord and Tenant Act to apply and have a 54 Act renewal. And there'd been other sort of cases that they drew attention to. A 1959 case called Number 1 Albemarle Street, where they decided that the ability to, you had leasehold premises, business premises, and they had a right to put in advertising signs on neighbouring property. And in that particular case, the court decided that the advertising signs were purely contractual. I take issue with that. There was a case called Moody and Steggles which said that advertising hoardings on land can be an easement. But that wasn't really discussed, but it was purely contractual, but at the discretion of the court on a 54 Act renewal, they could still be sort of added, if you like. So it seems that you can, according to, some of the cases at least, have occupation under an easement. But to have an easement, you also have to have a dominant and servient tenement. They discussed Ellenborough Park in 1956. Weston-super-Mare's finest hour. You have to have a dominant and servient tenement and a benefit to the dominant tenement to have an easement. So where's the dominant land? And they said that the demised premises next to you could be the dominant land, even though it wasn't occupied. But in any case, there was a 1938 controversial case called Resalvin's indenture, which said that the dominant land, there was a water company, and the dominant land would be the sort of, the premises itself, plus all the kind of services and the like could constitute the dominant land. So there was a dominant tenement, and my favourites, they didn't deal with it in the detail I would have liked, but they discussed whether you can't have an easement of exclusive possession, you can't oust the servient owner. Do you remember we did a case called Stenner and Cambridge District Council last year about a car park in Teignmouth in Devon, where they discussed their various cases and said that storing boats at the corner of this car park, which I've actually parked my car in, then that couldn't be an easement because you were ousting the paper owner from the land. But on the facts here, they said that there was no exclusive possession, and they didn't really discuss Stenner and Cambridge, which is just as well because it's due to be heard by the Supreme Court. It leapfrogged the Court of Appeal, and it's going to be heard by the Supreme Court in July. So we'll have a final solution or answer to that particular area later this year. But they decided it was an easement. They decided that you can occupy premises under an easement. The 54 Landlord and Tenant Act applied, and therefore you couldn't claim code rights.
Any final words on this one, Richard?
Yeah, it's yet another case on whether the 54 Act applies or not. We've done quite a few of those recently. Remember the two AP Wireless and On-Tower cases, where on one occasion they said there was no fixed maximum duration because either side could give 12 months notice at any time, no earlier than the end of the 10-year period. And also another AP Wireless to an On-Tower case where they decided on rather tenuous grounds it's a tenancy at will. So that particular issue has not gone away. And I say it depends, I suspect, quite very much on its facts. But keep your eyes open for later this year for whether you can have easements of car parking and storage and such likes.
There we go. Thank you very much, Richard.
Thanks a lot, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.